If they're pulling you over and they start talking about alcohol, you're getting arrested, you're not going home.
That's common though, right? Things happen, clients get arrested.
Just because you got arrested, that doesn't mean that they actually know what to do. What was on the video was not accurate to what the police ended up putting down.
Well, that's what they do.
By the time I got all the evidence, it was already too late.
If the police doesn't collect the evidence may be gone by the time we get involved.
On their report, they said that she admitted to drinking then driving, which is not true. That's just what they assumed. She never said those specific words.
I don't want to call you a miracle worker, but the result you got was created by you.
She was glad that I fought for her.
A lot of times that's all people want. Even in cases you lose, they want you to stand up and fight for them.
You're most likely going to get pulled over for something else and then get the handcuffs on you. So DWI is pretty important because it affects regular people, not criminals.
Welcome to the Iron Gavel. I'm Chris Washington, a criminal defense attorney with over 17 years of experience. Today we explore an amazing story where our hero faced almost impossible odds, but his client emerged victorious because of him. Today's guest is attorney Ruben Restrepo Jr. He practices in Houston, Texas. Ruben is one of those rare lawyers who cares about his clients and their rights. He's been practicing law for more than 5 years and came out swinging for justice after law school. So let's uncover the truth together. Our hero, Ruben Restrepo, found himself entangled in a DWI case where his client faced jail time as well as restrictions on her ability to drive. The stakes were high, and we will show you step by step how the situation unfolded. But first, let's learn a little bit about our hero, our guest, Ruben. So Ruben, can you tell us a little bit about yourself and your background?
I'm originally from Algiers area of New Orleans, Louisiana. I went to University of Louisiana, Lafayette, where I earned a bachelor's in business administration. I worked in retail, customer service, and banking for over a decade. And then I decided I wanted to chase my dreams and apply to law school. I went to South Texas College of Law, Houston, where I earned my law degree, and I have been practicing criminal law from almost the very beginning.
What inspired you to become a criminal defense attorney?
I would say mainly mentors in Louisiana, such as yourself and partner Harry Daniels. I remember you guys starting your law firm, and I was just working regularly, and you guys were, moving on up and doing better and better. And I just always wanted to do law. And so when I saw that and I would talk to you guys, I would think to myself, maybe I should try this. It just was hard to take that leap from already working to going to school part-time, and then plus all the regular stuff like movies and TV shows.
So how would you describe in just a few sentences what you do in your day-to-day role as a criminal defense attorney or as an attorney in general, because I know you may do a little bit more than just criminal?
Basically, I describe myself as a Christian, a husband and a father, and an experienced and aggressive attorney that cares about his clients.
What are you most passionate about in your work?
I care about getting the best outcome for my clients. It doesn't always mean a dismissal because I am realistic. Sometimes it just means exhausting all possibilities, and that's what I'm most passionate about.
So I always like to tell people, actually a new client this morning, Sunday morning, she came to the office, we met at 9 o'clock. And one of the things I told her is that there are a lot of attorneys, but the public struggles to know if an attorney is a good attorney, somebody who cares, or somebody who's just in it for the money. So my question to you is, what do you think sets you apart from other lawyers who may practice in the same fields as you?
I would say my expertise. I've invested a lot in knowing the field that I'm in. I market myself as a DWI lawyer, so I take a lot of CLEs for that very specifically. When it comes to immigration, which is the other thing that I do, I take on more complicated cases, so I'm also studying for those. And because I study for that type of stuff, I mean, I have people calling, even other lawyers calling me just to figure out when they have something that's a little bit more complicated than the norm. That's what sets me apart from others in my field.
See, that's interesting. One of the things you said is something Harry and I don't have. A lot of people who need immigration lawyers, how does that come into play with criminal charges? And how are you able to help them, whereas somebody who does not do immigration but only does criminal cannot help?
Well, I would say because when I originally started, I was only a criminal lawyer, right? And because I speak Spanish and I get appointments, I get a lot of people who speak Spanish and they'll be undocumented or they'll have some kind of legal status, but they won't be citizens. And so, citizens, it doesn't matter. You could just plead guilty and I could just do whatever you want without having to tell you, hey, wait a minute, this could lead to your deportation. And so because I kept running into those type of situations, or I would have somebody who was in jail, they would pay the bail, then it would go into ICE custody, and then that would create a big complication because sometimes they would come back because they would so-called forfeit their bond when really they were just in another government facility, but they would still forfeit their bond for the county. And so then that would cause a big problem. Their bond would be raised. They just didn't have enough time to ask for an immigration bond, and they didn't even know that they had to ask for an immigration bond. And so that's the kind of thing that I'm able to bring to the clients and tell them, hey, these are the difficulties that you're going to have. That doesn't mean it's easy to explain. And a lot of times clients are trying to, look left while they're looking right because essentially you're dealing with two different types of courts. But the advantage of being able to get an immigration bond while you're out on bond for a criminal case means that you're able to accept things like a probation because you're already out. If you're just stuck in jail, then when they're starting to ask you to do things like community service, how are you going to do that in jail? You just can't. What about classes? Well, they're not going to give you any computers to deal with. So you're just kind of stuck, and the leverage is with the state, not with the defense.
How did you learn Spanish?
I grew up in Spanish. Basically, it's my first language. I am a U.S. citizen, and I was born in Miami. And then about 6 months later, I came to New Orleans and just grew up in New Orleans. My dad's from Colombia, my mom's from Honduras, and so that was my first language. Now, I grew up in Louisiana, so as you can pretty much imagine, it's not like I speak the best Spanish because everyone pretty much speaks English there or French. So I did lose a lot of it, but it never really left me. I always understood it more than I spoke it. But when I came here to Houston, I basically had to learn to speak it again. And then I still have a bit of a gringo accent. Like sometimes my friends call me an Oreo or the Oreo lawyer. But I mean, hey, that's just the way it goes, right? A lot of times clients can give me, or potential new clients, they can give me some trouble because they're like, well, your Spanish isn't great. And I go, well, the judge doesn't speak Spanish, right? The prosecutor doesn't speak Spanish either. The police don't speak Spanish. Nobody cares about my Spanish on dealing with your case, right? When I'm dealing with an immigration, I have to translate everything to English. And, it's fine that some people can speak perfect Spanish, but that doesn't really help with your case, right? Do you want an interpreter or do you want a lawyer? That's what I tell people. I'm a lawyer that can speak to you and explain to you. And I have people that just plain speak better Spanish than me. So if there is an issue, they can kind of take over the conversation. So I never really have a problem with that.
The topic you're going to talk to us about today is a DWI case, right?
Yeah.
And why do you think it's important for our audience to hear about this case?
It's about how difficult a DWI case in the different types of criminal cases. Surprisingly enough, the most scientific, the most evidence-based cases are pretty much murder, sexual assaults, and DWIs, right? Well, murders and sexual assaults tend to be felonies, and then DWIs are misdemeanors, right? But the problem is that you're most likely not going to commit a murder, right? There's just not that many people dying, so a whole lot of people aren't committing murders, and not that many people are committing sexual assaults, right? Like there's more victims from one person than from a whole bunch of different people. And it's just something that's not prevalent. But what is prevalent for the normal person is going to be a DWI, because we have a community culture of drinking, and we have a culture that's depending on driving from here to there. We don't have that much public transportation, especially in a place like Houston, especially in places like Louisiana. Just you got to drive, and if you don't have a car, you're going to be in trouble, right? And
Right.
so when you have a culture of like you go to hang out to the restaurant, to the bars, if this was really such a big problem, then there wouldn't be any parking lots wherever a bar was. You could only just go to a bar on foot, right?
That's right.
But instead, you can drive to a bar, you can drive to all these restaurants that serve alcohol. So they expect us to drink, right? Now, I personally don't drink, but most people do drink. And then they drive home. And anybody can get arrested for this. I mean, what was his name? Richard Sherman. He's got 2 DWIs. Former Superman, Tom Welling, he's got a DWI recently. And Patrick Mahomes' dad has 3 DWIs. So, I mean, these are just regular people. They just keep getting caught. And guess what? None of them were in accidents. So, why did they get pulled over? How did they end up having a problem? Well, because it's the one thing that you're most likely going to get pulled over for something else and then get the handcuffs on you. So DWI is pretty important because it affects regular people, not criminals.
That's a load of information. I've done some limited DWI work, but I've never devoted that much thought into the logistics behind it. About really what you said is so true that somebody might go out to a bar, have a drink, which is what people typically do, and they're not intoxicated. They may not even be over the limit, but the minute they get pulled over, there's any alcohol involved, they immediately want to arrest the person that's driving while intoxicated. And
Exactly.
I wish there was a better way to say or to show that the person was drinking but they were not intoxicated. Here in Louisiana, even if they're below the legal limit, they can still be arrested for driving while intoxicated.
Yeah, and some of the counties over here, they don't even have overnight or after business hours or banking hours or court hours, right? Magistrates. So what usually ends up happening is there is no blood or breath collected, and that has to be collected essentially during a specific amount of time, right? Because alcohol does dissipate, and after about 2 hours, it's worthless anyways. So it's worthless to point and say, oh, this person was definitely intoxicated around this BAC. And so then at that point, they're just not even bothering. They're just like, look, we thought this person was drunk, and so you should think they're drunk as well.
How do you typically approach when a new client walks into your office?
Okay, so I basically asked the potential new client what they want to avoid. Like it's easy to ask somebody's goal, and their goal is always going to be to get a dismissal, right? But I haven't seen any evidence, so I can't even tell them if it's going to be easy to get that or not. And typically with DWIs, it's the one case where there's advocacy groups, right? There's no advocacy groups for retail theft, right? There's nobody out there, protesting with signs, hey, we must stop the retail thefts. Nobody really cares unless they're a business owner. And so when it comes to drugs and criminal mischief, even regular assaults, nobody's really out there. You really are only going to have things like domestic violence is going to have people, specific groups out there saying stuff, but also DWI, Mothers Against Drunk Driving. And they put out a lot of information. There's a lot of legislation that gets put out there that basically props up bad science. And so the prosecutors are trying to get convictions on this one, right? Because it's definitely something in which the public might come after them and publicly scold them. So they're not going to be as malleable as say, oh, look at this person who did some shoplifting. Let them take a class and get this dismissed, right? Or maybe somebody who was driving kind of reckless, but maybe they need to take a driving class and get it dismissed or do some community service. Here, they're going to want the whole kit and caboodle because they're going to assume from the get-go you have a drinking problem, right? And so I want to see what you want to avoid. Or you want to avoid jail time? Do you just want to avoid this on your record? Do you have a CDL? Things of that nature. But I'm very realistic with my clients. and I give them lots of ways to keep in touch with me. So that's how I approach it, because you can get in touch with me through a program that I use with messaging. I have a text message, and then obviously I have my office phone. So many people tell me, it's like, I had a lawyer, but I could never get in touch with them. I couldn't even speak with anybody when I called their phone. I have a team that works for me and that answers the phone, and then they can message me. They can even send me emails, all of those things.
What are some of the most common mistakes people make when they're first accused of a DWI?
Try to explain themselves, right? There's a reason why so many lawyers say shut the F up in all their little posts and commercials. Right? It's like you're trying to explain yourselves. And, I've had countless interactions with prosecutors and police where I show what the client said, what the defendant said makes sense. But like I said before, the prosecutors have limited experience, right? I mean, I'm from New Orleans, and being from New Orleans, it's a poor city, right? Especially compared to like a place like Houston or Chicago. Yeah, there's poor spots, right? But it's a rich city. New Orleans, especially when I grew up before Katrina, that was pretty rough. I mean, I'm talking about, I would get rides from people where they were starting their car with a screwdriver, right? And it was their car, and for some reason the key stopped working. They lost the key was broken. Well, you got to use your car, right? And then here I am being a criminal attorney, and I'm trying to explain to them that, hey, they bought this car and they thought it was legit. And then the prosecutor goes, how can they think it was legit? You needed a screwdriver to turn it on. And I just think to myself, so? But that's my lived experience. That's what I've seen. They've never seen that. This is their first job. And so they can't understand unless they mess up, right? Like I had a prosecutor one time. She didn't understand anything. She was perfect until she was arrested for DWI, which was hilarious, right? Then she was a little bit more understanding. And actually, I was connected to a murder case, and they ended up getting rid of that case, I think, because of that, right? And so because we know that they're not going to understand a lot of different things, right? That's why we don't want to explain. And a lot of times they're kind of being manipulative as well, the police officers, and they're kind of getting you to say certain things like, how much did you drink? People think if I say 2 drinks, that means it's not enough to be above the legal limit. Well, they're not going to believe you in the first place. And you just admitted to drinking. And so even if they didn't smell alcohol, I mean, there's no smellometer to tell me whether or not to confirm they actually smelled alcohol or not, right? It's best to just be quiet, call your lawyer. If they're pulling you over and they start talking about alcohol, you're getting arrested. You're not going home. You're going to take the sobriety test and you're going to fail. It only takes 2 clues out of 20 total clues in order to justify to a judge that you may have been intoxicated. That's all probable cause is, right? A 12% chance. That's it. So best to just don't go around explaining yourself, because that's just going to cause problems.
All right, that's great. I think a lot of people will benefit from hearing that. No doubt about it, because when they don't listen to us or our advice, it makes the case more difficult. And especially in a case like this on the front end, most people don't know how they should respond until they're in that situation. So you've given some nuggets that I think a lot of people will be able to use. In Texas and Louisiana, and quite frankly, I think in probably every state in this country, that advice is sound. So that's great. So I want to know, like, what is your process for dismantling or tearing apart the prosecution's evidence and creating a strong defense for your clients?
The main thing that I do is I evaluate the evidence. Look, I wait till all the evidence is in, and then that's when I do my evaluation. I'm trying to look at everything. I try to make sure that I know the law, and I question every time that they've made a conclusion. I've now seen enough cases where I am seeing the same language come up over and over again. So I kind of know where that should lead to. And a lot of times it doesn't lead to what people say. And then the main thing is I prepare, right? But I'll give you an example where a lot of times you'll see the language of the person supposedly was driving intoxicated. Well, that's not possible, right? The only way you know somebody was driving intoxicated, where you're going to put that as a police officer on your report, is if you knew that they were drinking beforehand. And then how would you have known that unless you were at the store or at the bar or at the restaurant? And then for some reason you ended up following them and then you saw them driving bad. What really is happening is that they're committing a traffic violation. There's a vehicle in motion, and then they're pretty much going to commit some kind of traffic violation, right? So, like weaving, failing to stay in a single lane, going between a bunch of different lanes. But if you really think about it, that is reckless driving, right? And so if they're saying intoxicated, which a lot of 911 reporters say, oh, I think this person's intoxicated, you should be like, well, did you see that? Do you know that they're taking anything? How do you know that portion? Oh, I don't know. It's just the way that they're driving. Well, they could just be driving terrible, right? I mean, I was a traffic attorney for a long time, and I saw a lot of stuff that you would just think was straight up driving while intoxicated. And there was no indication that they drank anything or took any drugs. It's just people were not paying attention, falling asleep, messing around with their phones, and oh my gosh, I need to get back, and I needed to get on this one. I didn't really realize I was drifting. So I always question a lot of those things. Don't get me wrong, it's very difficult to get a judge and a prosecutor who have no experience in traffic court to believe that, because their main experience will be DWIs.
Right.
And so everybody is intoxicated to them. So I do question that stuff. And when I'm in the process of a trial or an ALR hearing, I am questioning the police officers. And a lot of times I do get them to admit that there's no way that you can know if somebody's driving intoxicated. Because, I mean, they'll say, oh, they intoxicatedly took a wide left turn. A wide turn. People are used to driving big trucks and they do that. So that's what I do. I evaluate the evidence. I study the law, so I know the law. I question their conclusions, and I prepare.
So that brings me to two questions based on what you just said. One of the things I heard you say is that when it comes to tearing apart the prosecution's case and formulating your defense, you like to wait until you have all the evidence. Now, I know I do criminal defense as well, and I'm sure the same is true for you, that a lot of times when you meet with a client on day one, they want to know, can you win? What's my chance of winning? Give me a percentage. How do you deal with those type of questions, knowing as a lawyer, like, I really need more information before I can answer that?
Well, it's kind of like what I was saying before. I'm very realistic with clients. I tell them I'm going to be very frank and realistic with you. I don't know because I don't have the information. Most of the time, I don't even have the summary of facts. And when I don't have the summary of facts, I can't really make any kind of decision at all. So I just tell them, I'm only going to be able to go off of what you're telling me, and I can believe a lot of what you're telling me. But one thing I know is that you're not an expert on how these things work. And so you feel that you did pass the test. But did you know that it only takes 2 clues out of 20 total clues to make an arrest? And on no level is that going to be enough to get a conviction, but that's all it takes
for an arrest. People often get that confused. The police, they need very little evidence or anything to arrest us, people, members of the public. But that doesn't mean they're going to get a conviction, right? It's your job, my job, lawyers that do criminal defense. It's our jobs in general to hold them to the burden of proof, which is beyond a reasonable doubt. And to arrest somebody.
I even say I don't hold anything against a police officer for arresting my client, right? Great. That was a great decision you made. You were out there trying to save babies, right? You're trying to make sure that this person doesn't commit the crime. My thing is that what are the consequences of the action, right? So the consequences end up being something along the lines that you get arrested and you get charged. Well, they have more than just charging you. They can say, well, I don't really trust this and I'm not going to wait for you. So I'm going to have your stuff impounded. I'm going to arrest you and somebody can come and get you. at the station. They have that. They don't take that chance. Instead, they'd rather just arrest you and give you with a charge. The lawyers deal with it. And as a matter of fact, sometimes they even say that on the body camera. If you have a good lawyer, your lawyer will make sure that you'll get off just fine, except that your license is going to be automatically suspended just with that DWI. So they don't know the law like I know the law. So that's the biggest thing, right? Just because you got arrested, that doesn't mean that they actually know what to do.
All right, I got one more question before we jump into the case. I heard you mention an ALR hearing. What is that, and why is that important to your client's livelihood?
So with a DWI, this is another reason why they're so complicated, right? If you have a DWI, it's because you're driving or supposedly driving, right? And because it's connected to driving, essentially it deals with your license. Getting your license is a privilege, not a right. A lot of people hate hearing that, but it's just the truth. That's what case law has said. It's a privilege, not a right. And the reason that they say that is because you have to take a test to get this right to drive, right? To get the privilege to drive. You can't be blind and drive, but you can be blind and have a kid. You have a right to have kids. You have a right to have a house and have your house protected. It doesn't matter if you're blind or if you can't hear. That's what your rights are as a human being. So all those regular rights you can have, but driving does come with restrictions. So because they say that, essentially what they're going to say is that the law can be written to where you have to take the action. You as a regular person or through your lawyer have to take the action of preventing your license from being suspended. So it's automatically suspended. And the way that it's handled is, so there's civil court, there's criminal court, but there's another type of court that a lot of people sometimes it's hard to understand. It's the administrative courts, right? And so the best example I can give is Social Security administration. Whenever something goes wrong and you're trying to ask for something, you go through the Social Security administration and the administrative court. There's a judge who's going to make a decision and listen to both sides. They're going to just make a decision based on that stuff. It's never the same rules of evidence. There's always like these exceptions. And that's essentially what an ALR, an administrative license revocation. And so you could ask for a hearing and essentially fight it. What they're able to do that's very different than a civil court or a criminal court is that they can just do a paper suspension where you're fighting the case. They give you the papers that the police filled out, and then they don't have to call the police. And so it can become very complicated. You're subpoenaing the police, and if they don't show up, then the documents can't come in, but they may show up. And actually, the police officer did show up in my other case, and then we get to cross-examine them. Ends up being like a deposition. But the point is to fight it and try to keep the license from being suspended in the first place. That doesn't mean it will never be suspended, because if you take a plea, some kind of offer, or if you're found guilty, court can therefore suspend your license. Just the automatic nature of it has been prevented, right? And so when somebody's facing a DWI, they're literally facing two different courts. And one of the courts, they may not even know that they have to deal with. I mean, you're given documents, but when you're getting arrested, it's kind of hard to keep track of everything.
Let's get to the case.
Okay.
The case you are here to tell us about. Give me the backstory leading up to the accusations. Tell me about how long it took from start to finish to resolve the case, and what kind of penalties or jail time your client was looking at.
So it was a DWI second. So what that means is that there was an accusation of DWI, and either she pled guilty or she went to trial and was found guilty. But there's a conviction on her record for a DWI, right? Now, there's a bunch of different factors that come into it of how close it previously was. But the point is that there's a second conviction. Texas law used to be like, oh, if it was over 10 years, then it would be treated like a first conviction. They got rid of that. It just now goes up. And so you could be 20 years, be facing a DWI second. The duration of this case was approximately 9 months. And there was a trial, and it was essentially a 2-day trial. This is a misdemeanor A. So a misdemeanor B is basically a $2,000 fine max and up to 180 days or 6 months in jail. The minimum is just 1 day in jail or 3 days. I never could figure it out whenever they say that, but you basically can have whatever the minimum is for a regular misdemeanor B. That's what a regular DWI, if you never had a conviction before and it's below 0.15, but above the legal limit of 0.080, right? Now, misdemeanor A, if it's above 0.15, now you're facing up to $4,000 fine or 1 year in jail or both, right? You can definitely have both. And so every case is pretty much the same. You can have jail time or you can have probation time. Probation max is 2 years, but the minimum for misdemeanor A is 1 year or 12 months. Now there's an enhancement on a DWI second where the minimum goes from the regular 3 days to 30 days in jail, right? So in a county jail. So that's something that a lot of people need to keep in mind when they have a DWI second. So it's not something you're going to mainly get a time served on unless you spend significant time in jail before you ended up paying a bond. The probation, like I said, it could be 12 to 24 months, but there's a special thing that happens where a condition of probation is you go to jail for a minimum of 3 days, 3 consecutive days, and you get no credit for any days that you've already had, or 5 days if within the previous conviction was within 5 years. And then there's an automatic suspension of your license. So there is a discretionary on a misdemeanor B DWI where the judge can decide not to suspend your license, but here it's going to happen automatically. Also, with a misdemeanor A or B, if it's your first DWI, you can take a probation and avoid the suspension of your license. You cannot avoid the suspension of your license with a DWI second. It's going to happen no matter what. Now, the time frame is up to the judge, but it's still going to happen. That's basically the kind of the backstory of the case.
Tell us about when the client initially came into your office or reached out to you by phone, any initial doubts and fears you had, and any initial doubts and fears that she may have had.
Well, we met through a lead service where, she was just searching on kind of like Google, and then she filled out something. They sent it over to me. We ended up speaking on the phone. I answered her questions. Like I said, I asked, what don't you want? And she was like, I don't want to go to jail. She didn't want to go to trial. She said she was okay with a probation. The only caveat is that she knew she didn't drive while being intoxicated. So she wanted to see if there was any kind of way to get rid of the case. I was realistic with her. DWI-2s are harder to convince them to dismiss the case because they're like, hey, what are we talking about here? This is your second time. It is a lot harder, and a lot of times we do have to go to trial before they'll even consider any kind of dismissal.
Take us through the case. What happened on the day in question?
The police's story is very simple. There's a 911 reporter that calls for help of someone sleeping in their car. Houston Fire Department arrives and discovers a person that drank alcohol, and they call for the police. The police arrive, they speak to her. She admits to driving. She admits to drinking. She says she's too drunk to perform a sobriety test, so she's arrested, right? And then one of the things that happened is whenever somebody's arrested, because they're trying to suspend the license at the same time, they ask for a result, either breath or blood. She agrees to a breath test, and the result was 0.305 and 0.314. I mean, basically around the range of almost 4 times the legal limit. It was just an open and shut case, nothing to worry about. How could anybody try to go to trial? So that's basically what their story was.
So tell us how you dealt with the police's story, accusations, their point of view in defending your client.
She had 3 different things, right? What's her plight? What's her public perception? What's her legal perception? So her plight was that it was her second DWI charge, and she was constantly making sure that she didn't drink and drive and then drive. And so this was, on the back of her mind. Public perception was that she was being wrongly accused. She's like, wait a minute, I didn't drink, then drive. And I wasn't driving the way that it actually happened, right? And the legal perception was that she was just screwed. And so that's why she was kind of willing to take probation, but she didn't want to do any jail time, right? And the judge was kind of like, nope, it's a DWI 2. She's got to do her jail time. And I was like, okay, that's not going to work. I tried to tell them, evaluated the case. I watched the videos. I had spoken to my client, and I noticed that they didn't do everything that they were supposed to do, right? So she was arrested at the scene. The problem is that, most DWIs are the officers are the witnesses, right? And here, the officer wasn't the actual witness. There was somebody else, a 911 reporter, who was supposedly the real witness, right? Except she wasn't driving, right? It was a parked car. Sometimes police officers aren't the witnesses because of situations like this, or maybe somebody's going to the hospital. Here, she was cleared by HFD, so, going to the hospital wasn't going to be an issue. And so the way the case originally started is like they just gave me a bunch of evidence. And what they started with was they gave me the DWI evidence, which are documents, which is DIC 23, that's sworn affidavit from the police officer, DIC 24, where they're giving her her right for suspending her license. And that's where she agrees or refuses to provide a sample. The DSC 25, which is our temporary license, and within 40 days, her license is essentially going to be suspended, but we don't know how long or how short it's going to be within those 40 days. So that's why she's given a temporary driver's license. And then, of course, she can challenge it in the ALR. And so that helps prevent the entire situation. They gave me the breath test slip, the offense report, the previous judgment, 911 report, on-scene body-worn camera, and station video for the breath test. The specific legal challenge that I kind of ran into was, so her story was essentially very different. Her story was she got some really bad news and she was at work and it was very upsetting news, right? So, I'm going to be kind of vague about that because that's really unimportant. It's just that it put her in a mindset where she was emotional and she was crying. So she leaves, she's new to the area, she's not using a GPS, she ends up taking the wrong exit, and then she's like driving, she's like, I don't know where I'm at. She ends up in the wrong part of town in terms of trying to get home. And so she stops at a gas station and she just parks her car. And she's just like, I'm just going to be here, sit here, deal with this. She's crying, but she's at a gas station. She's like, you know what? Just like a lot of people, I'm going to get a drink to deal with this. She gets a bunch of drink and she's there for a significant amount of time. I'm talking about hours, right? And she's drinking, which is how she ends up getting such a high amount, right? And of course, she has to use the restroom and stuff like that. And when she does that, she throws away the drink that she's already drank, the cans and whatever. And so that was one of the problems that was presented, is that they were like, oh, well, look, there was only like half a can drank and there were no other empty cans in the car. And so they were doing the logic leap of, well, she had to have drank before. And it's like, yes, she did, but she had been there for a long time. And she was at a gas station. The surveillance video would show you that when she arrived. And so if you're disputing the time that I'm saying, then show me, right? That's your burden to prove. They didn't get that. And they're like, well, that's not our burden to prove because, we could just use our brains and say that that didn't happen. Another thing that happened is that they spoke to her. And then, like I said, she admitted to driving and she admitted to drinking. Well, her admission to driving, they asked her, where were you coming from? She said, from work, right? Like, how did she end up at this gas station? Well, she was coming from work. They didn't know to ask her more than that, right? They didn't say like, well, why are you at this gas station just, in this kind of awkward spot? Sure, you're legally parked, but it's kind of weird. What's going on? They don't ask her any of that. They're just like, okay, so you just came from work. They're implying that she just arrived, but they didn't say that. They just literally repeated to her. And the way that I took it was like, you're just repeating it. So, oh, you say you came from work? So you just came from work? Yeah, I came from work. She literally confirms that she came from work, not the just part. But to them, the prosecutor, just was very, very recently. Now, here's the problem. There's a 911 reporter. HFD arrives, emergency response essentially, and then they call the police to come out there. So a significant amount of time has already passed and the car had already been parked. There's no reason to know when the car got there, right? And so that was kind of a big thing. So the specific legal challenge I felt like they had was you know, proving operation. So I had to basically show that they can't prove it by proving that there's no operation. The other thing is the 911 reporter called and said that somebody was asleep in the car. They never got out of the car, right? They were in a truck. The 911 reporter is actually a wrecker driver, right?
Why would a wrecker call? What's in it for him? Is he just looking out for the public in general?
He said specifically that he thought it was an abandoned car. So he thought it was an abandoned car. He drives up to the car. So once he's there, he never leaves his car. Once he gets at an angle where he can see that somebody's in the car, he goes, oh crap, somebody's in the car. His conclusion is that that person is sleeping, right? He doesn't say that he honked his horn or anything of that nature. He just says it seems like they're passed out in their car, right? So he calls 911 to get the police out there, and then he stays, which means that he still wanted to tow the vehicle because his experience, he knows when there's a car that's just kind of just sitting there, especially at the time, somebody's been drinking and then they're just right there. And so then they get to tow the truck. That's what he got to do. So it was pretty clear to me that that was what was going on, right? So he called and he got to tow it. That's what everybody's expecting. I've seen that before. I've seen people where they get a flat tire, they're on the side of the road, right? And they're like, darn, I can't get home. They call for a tow truck driver. Tow truck driver arrives an hour later, right? And the person's been waiting in their car this entire time. So they fall asleep. You know, it's hard to wake somebody up. And what do? They knock on it and they go, hello, hello. The person doesn't wake up. The person's asleep. So they know that you're going to get paid more. One, they're going to get paid by the police to tow the vehicle. Then they're going to get to charge the person for towing the vehicle. So they're going to get paid twice, actually, and for storing the vehicle each day that it gets stored. They usually call the police. You know, this person has an incentive to call. The police should be questioning what they're doing, but everybody's used to this, so I kind of understand where they're coming from. The problem is somebody who is passed out in their car and they're not impeding traffic, you know, and they're legally parked, that's not actually somebody that you can go and arrest and you can just automatically assume that they're intoxicated. It doesn't even matter if they are intoxicated, right? You just can't do that because at this point, what you're saying is that somebody's being unresponsive. And when they're unresponsive, that calls for a wellness check, essentially. There's no legal term in Texas for wellness check, but there is a term called community caretaking. That's where I first started. 911 reporter, passed out person, calls for emergency response. Now, the police can be the first responders, right? The law says that all their actions have to be divorced from detection, investigation, and the acquisition of any evidence. So here, though, they were not the first responders, right? It was actually a first responder in terms of a fire department. So the fire department goes out there, and so then you have to click off 4 different things. What's the nature of the distress? What's the location? Are they alone? Are they not alone? The nature of distress is the fire department, they interacted with her. She was already awake, told them that she had already called for her parents to come and pick her up because she knew she couldn't drive, right? They took her keys from her. They ended up putting it on the hood of her car, but they took her keys from her and she was like, yeah, that's no problem. So as far as she knows, they have the keys. She's at a gas station, legally parked. There's nothing wrong with where she's parked. Maybe if like the gas station owner came out and said, hey, I need you to move your car or something, and she refused, then she could be, criminal trespass. But there wasn't anything of that nature. They never looked at anybody in that area. She was alone, but she did show proof to HFD that somebody was coming to pick her up. And so she was fine. She was alert. So she wasn't a danger to herself. She wasn't a danger to others. So they called the police essentially to take over and I guess babysit her, right? But her parents have lived far away because she really took the wrong spot. And that's something that can happen here in Houston.
I hate driving in that city. When I was in undergrad, I thought I wanted to go to U of H for law school. And then after visiting Houston a few times, I was like, nah, too much, too confusing for me.
You do tend to stay around your area, right? And then you get to know a lot of places, but I mean, it is a GPS city. You need the GPS over here a lot. But that's why she didn't move, right? And somebody was coming to pick her up. So the big legal issue here is The community caretaking portion has been taken care of, right? They checked her out. There were no problem. They checked her blood sugar. They checked her pulse. She was totally good. And nobody was asking her to move. So she literally could have waited there until her parents came, unless they were intoxicated. One parent was going to drive her home and the other one was going to drive her car home, right? So there's nothing really to investigate here.
In your legal opinion, at that point in time, the police, the firemen, the tow truck driver, they should have all just left.
Yeah, I mean, if you're going to sit there to wait for her, that's a different story, right? But just because she drank, there is actual case law that says somebody that's in a parked car, it says a mere act of sitting in a legally parked vehicle while intoxicated does not establish probable cause. There must be something more, an action of functioning in a manner to enable the vehicle's use. That's the biggest thing. And so they're trying to see, well, was the car on? Well, it doesn't matter if it was on because people can sit in a car legally parked to enjoy the air conditioning, right? Like you're just allowed to do that and not start an investigation that's not even reasonable suspicion, essentially, right? You definitely can't arrest somebody for that just based on that. And so then there's no community caretaking. Her distress has been, the 911 reporter's distress has been addressed, right? The police come and they start speaking to her. And then this is where all the problems comes in because she admits to driving, she admits to drinking in that order. But they don't take it in that order. They make the assumption that they have a hunch, and you're not allowed to have a hunch, but they don't take it as that. The way that it's presented in the summary, it's something that can't be overcome without testimony. You have to go through the actual suppression. It can't just be like, well, Your Honor, on their report, they said that she admitted to drinking then driving, which is not true. That's just what they assumed. She never said those specific words. The interrogator, she didn't even have the keys, so technically she's detained at this point. There's a custodial interrogation here. She doesn't do the sobriety test. They have nothing to show that she's intoxicated except for the fact that she says herself that she's drunk. But she's saying that she can't do the sobriety test now. So what ended up happening is that I knew that there was going to be a lot of issues. So my plan was, number one, I was going to go after this reporter to show that he had a vested interest in calling because he never got out of his car. They asked him, they were like, is the person unresponsive? And he was like, I don't know. I'm not going to check. What if they have a gun? He thought it was a man, not even a woman. So it's like, come on now. Why are we listening to this person in the first place? Right? Then there was the first responder who ended up telling the police like, hey, she did drink, but she was awake when we came. And we checked her out. She's just fine. Everything's good. Somebody's coming to pick her up. So the police should have been like, okay, well, if that's the case, then that's pretty much it. Now, I do feel like if the police wanted to, they could have been like, well, we're going to check with the owner to see if they're going to be willing to wait for you to come here. We're going to have to take you in and have you wait at the station because we're not just going to leave your car abandoned here for these people. And we're afraid that you might drive and you're not fit to drive. But they didn't do any of that stuff. They went forward with a DWI investigation when basically we have a community caretaking issue here. They don't have any indication that anything else happened. So I basically just use their training against them. So their training there's 3 phases. Phase 1 is vehicle in motion. Phase 2 is personal interaction. And phase 3 is the pre-arrest screening, right? Here, there was no vehicle in motion, just plain and simple. Now, that happens, though, right? You come across somebody, they've been in an accident. Well, that tells you kind of can assume with reason that the vehicle was in motion, right? And then the person admits that they were driving and they got into the accident. Okay, well, you have that. But here, yes, she admitted to driving, but where did she come from? She came from work. Why would you assume that she was drinking at work? That doesn't make sense to me, right? What kind of job does she have? Is she a construction worker or something? She's a regular paper pusher. They're not going to be drinking at work, right? And so the next logical question to me would be, were you drinking at work? And she would have said no. But what they tend to say is she didn't volunteer that information. Well, when you're getting interrogated by the police or interrogated by anybody, what you tend to do is just answer what's in front of you because you're freaked out. And then it makes sense that they're not going to explain everything. She didn't give a chance to explain, look, I was upset and, all the rest of that stuff. She only had a chance to explain their DWI investigation questions, right? And so she was just like, I don't understand. Why are you guys doing this? Why are you guys going towards and asking me these questions? Somebody's coming to pick me up. They like to say, we want to make sure you're okay to drive, but she's already said that she's not going to drive. So they can't say that.
Let me ask you this. One or two things. Did they ever search the trash cans to see what she may have already drank and thrown away? And
No.
Or did they ever get the video from the store to see, if she was getting in and out of her car throwing empty cans away?
And basically the reason is because they felt like she had just arrived through the way that they asked her the question. And the problem was there were two officers. One officer asked her that question and then told the other officer what she said, which wasn't really what she said, right? So it was paraphrasing, and it's a wrong paraphrasing. Then that other officer just accepted that as the truth. And so he didn't bother asking. He was the more experienced person, so he should have known, but he didn't have much experience either. One was only 6 months on the job, and he was only 1 year on the job. So I understand why he kind of messed up. It's just that the problem for me was more of the prosecution. The prosecution should have had the critical eye on their investigation. But to them, they were even jumping to the same conclusions. They were like, of course, just so simple. I don't feel comfortable giving her this. I said, look, she's willing to take classes. Let's get the case dismissed, right? If you want her to do something. But I told them what I was going to say, what we were going to say, which is that she got upset, got lost, ended up at this place, parked, drank alcohol from the store. And I was like, you would be able to prove it, but you can't prove it because nobody bothered to get that information. And I did try to get the information, but the response was that it had already been deleted by the time I had tried to get it. And, and I just didn't understand, by the time I got all the evidence, it was already too late.
That's common though, right? Things happen, clients get arrested, and if the police doesn't collect the evidence may be gone by the time we get involved, right?
Yeah, I mean, it wasn't too long because I was able to do her ALR, but the biggest issue was when I got the video evidence and I was able to review it, I realized it was at a gas station. If I just go off of what the police say, it was like, I almost felt like what was on the video was not accurate to what the police ended up putting down, right? I mean, it wasn't like way off. It just was, oh, I see why they wrote that. But as a defense attorney, like, darn, I wish they would have said, like, we were at a gas station. She was just parked and they made it seem like she was like almost on the side of the road. That's the way it kind of read. But then afterwards, I realized, oh, well, they didn't say that she was on the side of the road. Kind of just implied it. And so then I was like, oh, okay. And then when I looked at the video, I was like, oh, I really understood. It was like, if she wanted to, she could drive off, but that's not what it was, right? Like, it was a understandable way of putting it, but it was kind of manipulative.
Well, that's what they do. They're supposed to capture the facts as they happen. But, I mean, they're human. We all have our biases and beliefs, and if we become jaded in what we do, even us as criminal defense lawyers, we get so wrapped up in it that sometimes it's hard for us to take a step back and see the whole picture. So I know that's true for law enforcement officers, too. Some of it's, look, I tell people all the time, some of it's not them intentionally doing this to harm a certain person, but they are set in their ways, and it's our job as defense attorneys, and also it's the prosecution's job also review everything and make the right call. Just because somebody gets arrested does not mean they should be prosecuted and have their life or liberty at stake. The prosecutor has the power to stop it.
Like a police officer, I don't actually blame them for what they did because, like, you're saying somebody's coming over here, but they're not even here yet. Like, what are we supposed to wait? Maybe if they had called them, they took a little extra time. It is a bit much for a police officer. And they only, to make an arrest, it's just probable cause, right? So it's really on the prosecution to see, oh, yeah, they did the absolute minimum for probable cause. I mean, they didn't even do a sobriety test, right? And they didn't do all this stuff. And I pointed this out to the prosecutor. And one of my biggest things was I did tell them, The only part that's making me feel uncomfortable is I kind of feel like you guys are going to use this case as a practice in a trial. And I just feel like that's not fair. Let's just go ahead and have her do a class and just dismiss it. But there's significant problems. And I told them, I said, you guys are always asking for a legal reason to dismiss. I've given you like 3, and you still want to go forward? They were expecting me to back down because they were like, come on, Ruben. I mean, it's 0.314. That's so huge. How can you go forward with it? And I was like, okay, well, we're going to see. That's when I did the suppression, and then we chose a jury. We did a suppression. I cross-examined the police officer. It was a lot because the 911 reporter did not come. I'm like, that's the real witness. Like, how are we going forward with them? And the judge was like, well, I mean, they can go forward if they want to. It doesn't mean that they're going to be able to win. I said, okay. I never got the Houston Fire Department's information. I never got their information. And I was like, wait a minute. I did a discovery request and I never got their information. And they were like, well, you could have subpoenaed him. I was like, how? I don't have his name or anything. Right. And they were like, well, we're not even using him as a witness. I'm like, how can you not use him as a witness? He literally spoke to her. And that's the only way that the police officers had a reason to interact with her. And so they just felt like that wasn't the reason. It was because of the 911 reporter. And so the judge kind of bought it. And I was like, trying to get a reset. I didn't even realize that they weren't going to call the Houston Fire Department until like the weekend before we were going to go. And so I said, this is a material witness. But the judge denied me. It's like I was trying to lie. She was like, she didn't buy my story or something. I'm like, I don't understand what this is. They didn't provide this when I asked for this. And I asked for it very early on. I'm talking in July. I don't actually wait until I go to trial to ask for the witness list. I asked like almost immediately. I couldn't believe that we were actually going. And I was like, okay, in the suppression hearing, we don't go into the rules of evidence. So I actually was able to play it.
For the audience, can you tell us what a suppression hearing is and what your ultimate goal you're trying to achieve by going forward with a suppression hearing?
I did suppression and exclusion. And so this is outside of the presence of the jury. And essentially, I was going to voir dire or test the expertise of the police officer and hopefully suppress or exclude evidence. This is the legal battle at this point, right? So I make a legal case. A jury can kind of decide these things under Texas law, but it has to be kind of under dispute first under suppression outside the presence of a jury. And then the judge is going to make the decision. And so essentially I was like, this police officer, he wasn't completely truthful or correct in his documentation, right? Which manipulated it more to seem like she had operated the vehicle and said things that she didn't say. I was like, that's a big problem. There's a community caretaking issue here where basically you're doing a wellness check. She's checked out. You can, from a wellness check, discover that something is happening at that point, right? Or maybe something during the wellness check happens, right? So you're trying to check on this one person, and then the next thing you know, they're starting to swing at the police officers. Well, assaults on a police officer, that happened because of the wellness check. It's not something that anybody meant to do. I have had certain people sleep in the car. They would have been just fine. Could have won on a community caretaking issue. And then they wake up and they immediately put the car into drive and then move forward and then stop. Well, guess what? Now you just drove. And it is a bit unfair that you drove because of the interaction. But, the jury's allowed to make that distinction, right? And so that's where the suppression was coming from, where it's like, hey, they've already taken care of her. She has no distress. Why are the police now interacting with her? What's their purpose? Why are they asking her any questions? She's already been asked questions. She shouldn't be getting questions from everybody. If the police were the first ones there, it would be different, right? Because they would be the first ones there, and then they would be speaking to her, and then they would realize she had drank, and then it would be like, okay, well, we're going to try and address this, but we're going to have to ask you a little bit about, your driving. Where did you come here? Those are also questions that are useful for addressing it. Like, why are you here? What's going on? You're passed out. They might ask those type of questions. But when the emergency responders already handled that, there's no point. So now there's no point in asking them any questions. And so, okay, even if you figure that the judge will let that one go through, you got to establish operation. And they didn't. And so what I did is I asked very specific questions. I said, what time did she leave work? I don't know. What time did she arrive at the gas station? I don't know. What time did she have her first drink? I don't know. Where did she have her first drink? I don't know. Did she drink at the gas station? I don't know. Okay. Did she get up and use the restroom at the gas station? I don't know. Did she throw away anything in the trash can at the gas station? I don't know. How many drinks did she have in that vehicle? Because she obviously had half of a drink in that car. How many drinks did she have there? I don't know. Was the car on? I don't know. The 911 reporter even said that the car, he didn't know if the car was on, right? So you don't know that the car was on, right? I don't know. Was she legally parked? Yes. Is it illegal to drive? No. Is it illegal to be intoxicated? No. It's only illegal if you drive while you're intoxicated, correct? Correct. Okay. So was the vehicle ever in motion? Yes. When? I don't know. Was she in distress? No.
That's good. That's really good.
So it was a bunch of I don't knows. My strategy was this. Because of the suppression hearing, the burden is on me because I'm bringing it up. However, DWIs tend to be warrantless arrests. And when something is a warrantless arrest, it basically is unreasonable. It's considered unreasonable. However, it has to be brought up in the hearing as a warrantless arrest. It's my burden, so I get to call them up first. I don't like to stipulate that it's a warrantless arrest because the prosecutors get to go first. They already know kind of where I'm coming from, so they're going to try and rehabilitate before I can even ask any questions. So I'm like, no, this is my hearing. I didn't concede a warrantless arrest. After all those I don't knows, I said, did you get a warrant for this arrest? No. Did you make a phone call for it? No. You would agree that this was a warrantless arrest, correct? Yes. And I said, Your Honor, I think I met my burden. That burden should shift over to them. I passed the witness. She said it shifted over to them. And that actually creates it from probable cause to a much higher one, which I think is clear and convincing.
It's clear and convincing so people understand the highest burden in law is beyond a reasonable doubt. That's to find somebody guilty of a charge and send them to jail or prison. Clear and convincing evidence is the burden or the burden of proof that's necessary if you were trying to take somebody's children away from the biological parents. So that is a pretty high burden as well. At that point, since you met your initial burden in the suppression, it shifted to the prosecutor to prove by clear and convincing evidence that what?
That it wasn't an illegal arrest, that they didn't do the community caretaking, right? And that they had everything that they needed. You know, if it was a legal arrest, then they were going to be able to establish that she didn't do the sobriety test. They read her rights in terms of her license, which is the GIC-24, and then she agreed to give the breath test. She's agreeing to provide and essentially waiving her Fourth Amendment right to a seizure of her breath, right? Which is considered physical evidence. So then that would have been able to come in. I had a strategy for that as well, but I didn't think that I needed to get that in the beginning. What they did when it was their turn to ask the questions was that they asked questions like, did she admit to drinking? Did she admit to driving? Did she say that she was too drunk? So there's a lot of stuff that she said, right? They didn't address any of the parts where I was like, what was this? You don't know, you don't know, you don't know. As soon as they finished, the judge was like, okay, I've heard enough. My finding is that it was an illegal arrest.
Wow.
And they were shocked.
At that point, the case is over, right? Your client gets to go home.
They were like, we need to convene, Your Honor. We need to convene. And so they did. So I actually didn't even know it was over. I was like, oh, I wonder what they can do. So I was just kind of waiting around. And then the judge started seeing other cases and we were just waiting around. Then they came back in. We got back on the record and they were like, we want to read some case law into the record. And it was some case law that said that, you know, if it's okay to believe that if somebody operated because of so-and-so. But I know those things. And somebody was on the side of the road. One was at a gas station, right? So it was very similar. They had looked at the video and that person had just arrived.
That's a huge difference. They shouldn't have even brought that case in. That case actually shows that they didn't do what they should have done.
The funny thing is, they're saying this after the judge already made her ruling. And so the judge was like, I've already made my ruling. So you can just read this. And she was like, Ruben, do you have anything to say? I was like, no. Because she already made her ruling. We already chose a jury, so double jeopardy already attached. Just over and done with.
That's a lesson for young lawyers for sure that you just gave. It's a nugget any young lawyer should remember. If you are winning or if you have won, just shut up. The judge has already ruled in your favor. No, judge, you've taken care of it. I don't have anything to add.
They dismissed the case, and then we were able to go home.
Tell me about your client.
She made a mistake one time with the DWI, and I feel like she learned her lesson. I don't think she had a drinking problem. She just got pulled over. And then the only thing that happened with this time was the news was so upsetting that anybody who would hear what actually happened to her would be like, oh, yeah, I would have done the same thing, right? It was a confluence of bad circumstances that led to where she was still there. If she was closer, her parents would have already picked her up, but then she would have never been my client, right? That happens sometimes, right? And so it's just that she was willing to go to trial. The judge doesn't like dropping down to DWI 1 so that the person doesn't have to do the 3 days, because she was willing to take a probation, right? And just to avoid a trial, right? But I was telling her, I was like, okay, well, if they don't want to accept this, then we're just going to go to trial.
I really want to know, what was her reaction when the judge said those powerful words dismissing the case?
She was very, very thankful for us because of the way it happened, right? It's like I'm literally lambasting this police officer with a bunch of questions and stuff. My assistant was there, and my assistant even told me afterwards, she said, when he started saying, I don't know, she was like, oh, he got him. We won the case right here. But I didn't feel that way, and so I didn't even know that. And so then when she all of a sudden said, she's finding this an illegal arrest, I was kind of like, oh, what's going on? And then they were like, no, we want to confer and bring up some case law. So I was like, okay, so they must know some kind of way to get over her decision, because like sometimes we just like, well, I haven't experienced everything, so they must know some kind of thing that I don't know. We were just kind of waiting around, and then the judge, instead of like waiting, she just started going with her regular cases. It took them a while. They took a plea, they did a bunch of resets, so we're literally just kind of like waiting. Then I had to approach without the client, as approaching as if the jury's still not even in there. So when she said it, I'm literally away from the client. So I had to go back to her. And so it's like, so she heard it away from me, right? So it wasn't even like where we could like celebrate. We had to immediately start worrying about like, okay, well, we got to get the removal of the interlock because it's a requirement for DWI 2, a bond condition by law. So we got to get that or else she won't be able to get it off. But afterwards, she was very happy. She gave me and my assistant a hug. She was very, very happy. She was glad that I fought for her.
A lot of times that's all people want. Even in cases you lose, they want you to stand up and fight for them. Based on what happened in this case, what would you say are some of the lessons you learned that will allow you to help clients better in the future? And two parts to this question. Based on what happened to your client in this scenario, what are some legal reforms you would like to see?
I'm not sure if there's much of a reform that can happen, but it's one of those situations where it's like the law is already there. You're supposed to investigate, right? There just wasn't a real investigation, right? And what can you do from there?
So you just want the police to do their job, right?
Yeah, I mean, the police do their job, but also the prosecutors. I just wish they would take a different tack because, I mean, this is a real person who's going to be affected by this. I understand the feeling like it's going to be so easy to win this case. It's their second time. You're not given any kind of quarter, but you're not listening to an experienced lawyer, right? I've been doing this for 5 years now, over 5 years, and a lot of times I'm talking to people and I would say the way that they speak to me is like I'm just started. I know you just got hired. I've never seen you before, right? And you're not going to be here like 2 years from now. So, why are you speaking to me like this? A lot of times I know so much, especially with like DWIs. I do get a lot of cases dismissed for kind of almost like, I can't really even explain it reasons, right? Like I just happen to point out this one, specific thing. Police officer maybe had lied about something, or they didn't do this, they didn't do that. And then the case just ends up getting dismissed. Like they just don't want to deal with that much stuff. It's not something I can use again the next time. So I call it like a miracle that it got dismissed.
You created the miracle. The miracles are created by the lawyer's hard work, devotion, dedication, persistence, and just a refusal to quit, like a desire to really stand up for that person. I don't want to call you a miracle worker, but the result you got was created by you.
My problem is like the way that I think about things is what can I do in terms of, can I duplicate it the next time? If I can't duplicate it, that's when it's kind of like almost a miracle, right? Because it's like I can't duplicate it. I mean, it's just from work. It's not something that's going to come up a bunch of times where I'll be able to duplicate it. What I do look for is stuff that I can duplicate. And that's my main thing. And that's because of that, that's where I have the experience and I'm able to go to the prosecutors and kind of show them I do have that experience. And then to connect it to what I was saying earlier is that the prosecutors don't treat me like I do have that. They just think I'm just saying stuff. And I'm like, come on, I'm telling you this.
They treat me like that after 17 years. And I just say, okay, that's the game we're playing today.
That's fine. Let's go. Funny enough, I would say this. A part of me does feel like, and I did tell my client this, and I didn't know how she was going to react, but she was just like, okay. I did tell her that this was my second win. The other win was an actual not guilty in that court against these prosecutors. And so I did feel a little bit like maybe they were going for a little bit of revenge because to them, it was so much clearer on this case. But I knew, I was like, no, I'm telling you guys, I don't think a jury's going to be able to believe.
This is the wrong case to get your revenge on.
A part of me does feel like that's kind of what happened. But that's why I review the videos. I do try to look at it and I do question everything, right? I've just looked at the police. I use their own evidence against them. The DIC 24 says reasonable suspicion for a stop or consumption of alcohol, right? That's where I start. Well, so you need to stop them first. And that's the number one thing, right? And that goes with vehicle in motion.
Right.
But then you have to go to another reasonable suspicion. And then that's where I trip a lot of officers up and I go, well, you agree with me. You don't know if they're intoxicated just by looking at their driving. It would be reckless driving, not DWI, because then you're making a hunch. I question a lot of officers on their knowledge. And funny enough, this one was a 2-day deal, right? So what happened is the judge kind of wanted me to go forward, but she had to go and teach like a class or something, right? So I was questioning the officer, but then I had to stop my questioning until the next day. They kind of knew what I was going to do, that I was going to question this officer. So one of the first questions I asked, I was like, what are the 3 phases of a DWI? Which I told you earlier, vehicle in motion, personal interaction, and pre-arrest screening. And he said all of those so clear.
Yeah, definitely prep. They prepped the hell out of him.
They knew where I was going to go. And I think if I had asked him on day one, he would not have known. And the reason I believe that is because that's the first part, right? But when we got into kind of the nitty gritty, more minute things, that's where he kind of started messing up. And so it's like, there's only so much you can really prepare for. The police officers have to show up. Most of the time they don't. They don't want to be bothered. It just depends on the police department. Small police departments, a lot of times they do show up. Big police departments like Harris County, Houston Police Department, a lot of times they don't show up. Or if they're very new, they show up. They've just taken that course and I go, tell me about the HGN. Tell me about the walk and turn. Tell me about it. How many clues does it have? I can't tell you how many times they'll tell me there are 6 clues on the 1-leg stand when there's only 4.
They administer tests. They don't even know what the requirements are.
They don't know the 3 phases. There's just so much that they don't know. And they go something like, well, I don't have the manual. I'm like, you're an expert. I don't want no doctor coming up here saying, well, I need the manual to do a heart surgery.
Find me another doctor, please.
What are we talking about here? So you have to be able to explain this stuff because, we have to explain this stuff. Like, nobody's going to want a lawyer to say, well, I don't know. I've got to do some research on what are the elements to the crime. They're going to expect you to at least know that part. And if we're talking about something that you're supposed to, collect the clues, and you don't even know how many clues there are, like, come on now. And so that's a lot of times what I do. And then I go, look, they're not qualified to speak on this stuff, so we shouldn't include any of that stuff. And I do that when we go to trial. And I have gotten officers where their entire sobriety test is excluded because they just don't know.
That's not a easy feat, I don't think, or even a common feat of getting the entire sobriety test excluded. You've been able to do that in several cases now.
Like 1 or 2. In the ALR, I do it a lot more, but in the actual trials, only 2, I think. And then you just kind of go forward with the case. You can still lose a case even without it, right? Because, somebody's been in an accident or something. You don't know what the jury's going to, hold on to. But yeah, I have definitely done that. So that's part of the questioning, right? Like, I don't know if they're not going to know. I mean, I'm reading this report and they should know everything that's on there. Something that I learned from you guys: offense reports, thorough, accurate, and complete. If it's not on the report, then it didn't happen, right? And then here they are, they're testifying to all this extra stuff. Can you tell me where that is on the report? When you find it, I want you to go, aha, it's right here. They admit that it's not in there. And so it becomes clear that they're just saying stuff to boast their testimony. And it's like, we're not going to accept that. I mean,
I'm not going to let you get away with that.
I had one case, it was an assault case, and I did that with an officer. I was like, you're not supposed to interview people, two witnesses together. He was like, there weren't two witnesses. I was like, wasn't there two witnesses though? There was the witness so and so, and then there was the complaining witness. And so, in order to be correct, he said, I've never heard of complaining witness. I was like, what? I couldn't believe he said that. And I was like, you wrote complainant down. He was like, yeah, complainant I've heard, but not complaining witness. Ooh, that was rough. Because then I had to basically destroy his credibility. And I had to be like, well, that complainant can be called to the stand, right? And right now, you're a witness, aren't you? You're testifying as a witness. So anybody that testifies is a witness, right? The witness may stand down. Have you heard of that? So that means the complainant is a witness. And you had the complainant and their witness together, and the complainant told their entire story in front of the other witness. Aren't you supposed to separate everyone? If they tell conflicting stories, you would know. And he's like, no, because if they tell the same story, then it's the same story. One juror went,
that's absurd. Like, clearly, anybody with common sense knows if you're sitting there and you hear this version, you're going to adopt some or all of it.
right. I mean, unless you just like are kind of against that person or you just feel it. And then he told his story in front of her. So he's definitely not going to change his story while in front of her. Like, come on, man. That's something that I've done before as well. I'm like, no, I use their evidence basically against them. At least I try to. I can't always do it. Sometimes it's like, oof.
That was a really powerful story, a really powerful case, an amazing result for that client. But there's going to be more clients in the future. So if someone is watching this video and they find themselves accused of a DWI or have a family member or friend facing a DWI, especially in your neck of the woods in Houston where you're located, what would you say is the first thing they should do if they find themselves on the side of the road with the lights on behind them, the blue lights, or at a gas station, as in this case, and the blue lights are behind them? What's the first thing they should do?
What I tell people is they're pulling you over for a traffic violation. And so for every traffic violation, your driver's license is needed or ID is needed, and your proof of financial responsibility, which is your insurance, right? So the majority of people have these things. So obviously there's, a lot of people who don't have it, but just get your driver's license and your insurance already out. Like, you got a little bit of extra room. So start getting it out right when you're putting your signal light on, start getting it out. And then there's going to be a little bit of time where the police is going to get out of their car and come to you. Just have it ready. And then that's going to be all the identification that they need. And so if they are going to give you a ticket, they're going to just give you a ticket right there, and you don't have to explain yourself. A lot of people don't feel comfortable not explaining themselves, but think about immigrants who are here legally, but they just have trouble speaking English, right? What are they going to say? Half the time they just say sorry because that's the only words that they know. They just use gestures, right? You don't have to say, I was coming from here and there. Why are you asking these questions? Just give me the ticket. I'm ready to go. And you don't have to tell them that. You can be like, here's your driver's license. Here's your proof of insurance. You already have that stuff, so you don't have to worry about it.
Driver's license, registration, proof of insurance. After that, is it fair to say that the person can just be quiet? They don't have to answer any more questions?
Right. They can just act like they don't understand English. They don't have to say, no, speak English, right? They can just act like it, right? And then that's it. I would just say, if you've been drinking, they're going to smell something, right? I mean, I've had cases that I've gotten dismissed. They smelled alcohol. My client didn't drink. My client said they didn't drink anything. They still got arrested. And then they took the blood test and everything came back 0. I've had about 20 clients like that.
How does that happen?
Because it's the time frame, and for whatever reason, it's Texas. The way that people speak, they sound like they're possibly drunk or been drinking something, but really they just have an accent, or, I mean, just having an American accent, right? Like, well, everything's fine. What's wrong? Oh my gosh, you're drunk. That was slurred speech. And they're just assuming that you're there. And maybe you're like, a lot of times I have this problem when people are speaking to me, they'll ask me a question and then I'll just kind of like space out and start thinking about it and have trouble saying exactly what I want to say, right? Well, red glassy eyes, you'd be asleep for that.
My eyes are always red. I got the worst allergies in the world.
I remember I had one client, he didn't have anything and the case got dismissed. But when I first met him, I was like, were you smoking? He was like, no, I don't smoke at all. I was like, oh, okay. But his eyes were like, I thought he was toting right then and there. Actually, I did smell something. He was waiting inside the courtroom and somebody in the courtroom had toted up. So I thought it was my client. And then I realized afterwards that when we had got away from it, it was still lingering, but then, it dissipated. And I was like, oh, it wasn't him, because I would have still smelled it. I've definitely had a lot of people like that. They just pull him over. And the way he spoke, he was an older black man. And he was, well, I don't know why they pulling me. Oh, yeah, it's ridiculous. I was like, I know why they're not going to arrest you, because your eyes are bloodshot and your normal speech is slurred. But yeah, he didn't drink. And I've had that with a lot of people. And some people are just really sleepy. That can also be a big problem. And they were driving terribly, just for a moment, but just in front of the police officer. And the police officer just thinks it's 1 o'clock in the morning or it's 11:50 p.m. Come on, you weren't drinking? Get out of here. I don't believe you. And then some people have been drinking, but it was like midday. And they asked them the question, like, did you drink today? The answer is yes. They don't say how much did you drink, or sometimes they ask and they go, well, I don't really remember. Why don't they remember? Because they drank 12 hours ago, right? And so all of a sudden now they're smelling alcohol, but they're not really smelling alcohol. It's from a long time ago. That can kind of lead to stuff. But where it mainly happens is people who fall asleep on the side of the road. So they're just going to automatically assume that.
I think I have learned a lot here with respect to a DWI defense anyway. And I'm going to steal some of your questions. If I get an officer that I can set up the way you did, I'm stealing it. I might forget to give you credit, so I'm going to give you credit right now. I'm going to use it.
Hey, there's no problem. I steal from everybody, right? I'm always asking people, like, what do you do? Like I said, I mean, a lot of this came from you guys. I want to know, is this thorough, accurate, and complete, right? It's like, if it's complete, then how come it's not as complete as all these other guys who teach us how to do sobriety tests and you don't do it right? Like, come on, man.
And these 10 things you said today that are nowhere in this 12-page report.
And I try not to get too tough with the police officers, because I did have a case where I lost. The guy was found guilty. And what they said to me was, oh, that police officer was the worst. He shouldn't even be on the force anymore. And I was like, well, how could you have found my client guilty? And they were like, well, you thoroughly embarrassed him. And I was like, okay, so me embarrassing the police officer was the punishment, versus what the punishment is supposed to be is not guilty.
That's terrible, but I do believe sometimes if we're over aggressive or mean or rude or belittle any of the witnesses, not just law enforcement, it can be held against our clients.
They want to punish the person, but they feel like you punished them. That was the justice. But it's like, my client's on trial, so my client deserved justice, right? And now my client did drink, so I don't know what to say too much, on that one. It's one where I learned that I don't get too aggressive. I just show that, hey, they didn't do a correct job, right? They're the people that's making the arrest. And that's how little evidence you need to make an arrest. You could do a bad job and still make an arrest. So now we don't have probable cause.
Have you ever heard the saying that as the lawyer, you should never get angry or upset with the witness? You should just present the facts or evidence or your questioning in a way that the jury is upset and angry with the witness.
I've never heard that, but I agree with that.
If there's somebody out there who needs a lawyer to defend them in DWI either now or in the future, what's the best way for them to reach out and make contact with you?
Well, I got a bunch of different ways. Obviously, the easiest way is just call me 713-714-7330. 713-714-7330. I have a website, Restrepo, DWIlawyer.com. That's my logo, DWI Lawyer. So you can send me a message. You can schedule a consultation with me. I'm available. So just reach out to me and we can try and fix your situation. I can't make any promises because any lawyer that makes promises is lying or hoping that they'll be telling the truth.
That's right. I can't make any guarantees or promises.
But what I can promise is I'm going to work my damnedest for you.
That's what I tell people. My promise is that I'm going to give your case 100% of my time and ability to get the best possible outcome. What about social media? Are you on social media?
I got Ruben Restrepo Law on TikTok. Other ones I just have Restrepo ESQ because I couldn't get, like, I didn't have enough words or letters to get the at Ruben Restrepo Law on the other ones, but it's usually Restrepo ESQ on Instagram and Facebook. Or you just put in my name, Ruben Restrepo, and then you'll see that I'm going to come up. I post at least 4 times a week just talking about different things, DWIs, gun cases. So yeah, definitely follow me.
It was good talking to you. I hadn't seen you in
Yeah,
forever, so keep pushing, bro. Keep pushing.
I will. You too.
All right, man. Take
I
care. Have a
appreciate
good
you.
night.
All right.
Thank you all for watching this episode. This attorney, Ruben, I've known him for a very long time, and he's always been one of those guys who's going to go above and beyond to do a good job. He taught us all, including myself, a lot with respect to DWI defense. If you're in Texas, especially the Houston area, he's the guy to go to. If you're in Louisiana, you can look me up, Daniels and Washington Law Firm. If you found this video helpful to yourself or someone you know, please hit the like button, subscribe to the channel, and send the video to them. And please come back. My goal is to release a brand new episode every 2 weeks. The Iron Gavel, signing off.